In the name of Almighty Allah, the most merciful, after the completion of our uh, Companies Act 2017's basic concepts, today we are starting another facet of this subject. As you know that the title of our course content or course subject is corporate governance or corporate law and governance. And primarily, on one hand, we are to study the Companies Act 2017, which is in fact corporate law in Pakistan, or this is the law promulgated in Pakistan to regulate the corporate sector. And at the same time, we have governance rules, which are primarily meant for listed companies, because listed companies are the companies where the stakes of general public is involved, and where the equity market is based upon, or this is an area which is in fact meant to cater the needs of shareholders and stakeholders. So in today's session, we will commence our work on corporate governance. If you recall, in our previous session, we have discussed the initial understanding that what is the corporate governance, and we have in fact reached on one key point, that is that on one hand, the purpose of corporate sector is to maximize its profits, but that maximization of profit is not at the cost of environment, is not at the cost of public good, and it's not at the cost of people who are involved. So one has to maintain an equilibrium, and to maintain the rights of the business and the duties, and at the same time ensuring that the rights of stakeholders are not compromised. So this is what in fact we have discussed in our previous sessions, and today I will be introducing the relevant law actually, that is corporate governance rules. So we will read through these rules and discuss them point wise. So let's begin that discussion. And let me invite, first of all, Mr. Raza Rahman to do the reading of screen which is being shared. Mr. Raza, please.
Yes, sir.
Yes, Mr. Raza. The screen which is visible, please start reading, going through it.
From notification, sir.
Yeah, from notification. This is issued by Government of Pakistan and of Securities and Exchange Commission of Pakistan on behalf of Government of Pakistan. And this was Gazette notified on 25th of September 2019. Yes, Mr. Raza, please.
Well, in exercise of the powers conferred under Section 156, read with Section 512 of the Companies Act 2017, the same having been previously published in the Official Gazette Wide Notification SRO 485 2019, dated 23rd April 2019, as required under proviso to subsection 1 of said section 512. The Securities and Exchange Commission is pleased to notify the following regulations, namely.
Thank you very much, Mr. Raza Rahman. Actually, let me explain one thing, that these regulations, these are called subordinate litigation, subordinate legislation. If you're taking note of this point, do bear in mind that these regulations, and if there are any rules as well, and any circulars issued, which are commonly known as SROs, these are called subordinate legislation. The parent legislation or parent statute is Companies Act 2017. And as you have read, that section 512, that section empowers the concerned regulator. In this case, we have Securities and Exchange Commission of Pakistan. That is the regulator for corporate sector. Now, this regulator has empowered the this legislation has empowered the Companies Act 2017, Section 512 has empowered the regulator, which is Securities and Exchange Commission of Pakistan, to make rules and regulations. So, as Mr. Raza Rahman has rightly read, that under Section 512 of Companies Act, these rules are promulgated and these regulations are framed. And so the chapter 1 actually deals with the preliminary aspect of these regulations. So let me invite Ms. Hira Nadeem to share with us short title and commencement of these regulations.
Okay, so short title and commencement. These regulations shall be called the Listed Companies Code of Corporate Governance Regulations 2019. Secondly, these regulations shall apply to the listed companies based on comply or explain approach, except the requirements for which it is explicitly stated as mandatory, and it shall be the responsibility of the board of directors, the board, to use this approach wisely, and of investors to assess differing company approaches thoughtfully. Thirdly, these regulations shall come into force from the date of its publication.
That's right. Thank you very much, Ms. Hira. Let me explain some of the key points discussed in Regulation 1, and then, of course, in sub-regulations 1, 2, and 3. Of course, the short title of these regulation is the regulations for listed companies, or we call them corporate governance rules and regulations. So these are meant for the listed companies. And this is important to point out that listed companies are those companies that which are traded on Pakistan Stock Exchange. You can buy the shares of those companies which are available for trade, which are available for investment. And these are almost 500 companies which are traded or which are enlisted at Pakistan Stock Exchange. So specifically, these rules are meant for the listed companies. Now, the second very basic concept is discussed in sub-regulation 2 of regulation 1, and that is comply or explain approach. We will read the definition of comply and explain approach in a minute. So there I'll be able to explain that what does this approach means. And moreover, these regulations are mandatory. These are compulsory. And if a company is not complying with these regulations, of course, there are penalties and there is a standard scale given. There are 3 levels of penalties are given in law. So according to that violation or infringement of these regulations, that penalty can be imposed by the regulator. The third sub-regulation explains that these regulations will come into force from the dates of its publication. You see, this is important, that any regulation which is framed or any law which is promulgated has to be gazette notified. Gazette notification that precisely means that that is available to the public and that is provided to the print and electronic media, those gazette notifications. And those gazette notifications are also provided to the libraries of district courts, high courts, ensuring that there is, in fact, it is in the public knowledge, and so that this excuse shall not be taken tomorrow, which is commonly known as ignorance of law is no excuse, that someone come forward and say that, well, these regulations are framed fine, but since these are not gazette notified, we did not have any knowledge that these regulations exist. So the existence of these regulations come from the date of its publication, and this will be considered that if it is pub, it is you see, it is published in the official gazette, prima facie this will be considered that these are in the public knowledge, these are in the knowledge of everybody, and no one can take this plea or excuse that it isn't in his or her knowledge. So up to section 1, up to regulation 1 and sub-regulations 1, 2, and 3, I'd like to invite questions, please. Yes, any question, please? So let me pose question if there isn't any. Ms. Ivan Mujahid, what have you understood from sub-regulation 3 of regulation 1? Please explain in your own words.
So you said that these regulations they should come from they should come into force from its publication. They should be brought into print and media, and they should be available for the general public.
Okay.
Yes.
So the very word actually gazette notification, that means
Yes.
that there is a Press of Pakistan which is specifically assigned the duty that the Press and Publications Department, they will publish all these regulations and provide copies of the same to the electronic and print media for the awareness of general public. Good. Let's have a second point, and let me ask Mr. Taimur Idnan to share with us that what do you think that why these regulations are specifically meant for listed companies? In your view, why is it so?
Sir, because it's a responsibility.
Mm-hmm. It is the responsibility, but you see, these are specifically meant for listed companies. But whereas you know that there are lots of companies operating, which are private limited companies, which are not listed on Pakistan Stock Exchange. So why these regulations are precisely meant for only the listed companies, not for unlisted companies, or not for the companies which are not listed on stock exchange, or not, their shares are not traded, and these are private limited companies. In your view, why this is limited to the listed companies only?
Sir, I apologize. I wasn't really paying attention before, but you can ask me questions from here onwards as
Okay.
well. I'll answer all of them.
No issue at all. Ms. Minail Amir, would you like to give your thought that why these are specifically meant for listed companies? Yes, Ms. Minail Amir, can you respond to my question? Okay, let's see if Mr. Hamdan can respond to my question. Mr. Kamran Shaukat. Mr. Ali Manan. Mr. Abdul Rafi.
Yes, sir.
My question, would you like to respond to that?
Sir, I didn't hear it properly. So can you repeat, sir?
Well, let's see if Mr. Amin Qureshi has heard it properly. Mr. Amin, please. Yes, Mr. Amin Qureshi. see if Miss Aisha Zafar can respond to my question. Okay, my question is a very simple question. And the question I have posed is that in sub-regulation of Regulation 1, this is said that these regulations are meant for the listed companies only. The reason thereby, and not meant for private limited companies. The reason is that on listed companies, there are stakes involved. The stakeholders, the shareholders, they invest in those companies which are listed on Pakistan Stock Exchange. So in order to safeguard their investments, this is required that there must be some regulations framed in order to make sure that the rights and privileges of shareholders and stakeholders are safeguarded. This is why these regulations are specifically meant for listed companies. And unlike listed companies, the private limited companies, the stakes are of only those who have formed those companies or who have got those companies incorporated. So since the stakes, general public stakes are not involved, so these regulations are meant where public investment is involved, just to safeguard that investment. Okay, so now let's move on to Regulation 2. This regulation is titled as Definitions. So let me invite Ms. Tehreem Nadeem to do this reading.
Definitions. In these regulations, unless there is anything repugnant in the subject or context, an extra means an extra appended to these regulations. Comply or explain approach means discretion of a company with respect to non-mandatory provisions of these regulations, either to comply or provide appropriate explanation as to any impediment in its compliance in the compliance report along with financial statements.
Thank you very much, Ms. Tehreem Nadeem. Basically, if there is nothing repugnant, so the very word Ms. Tehreem has read is repugnant, and comply or explain approach is defined here in Regulation 2. We call it Clause B of Regulation 2, which explain the very concept of comply or explain approach. Now let's understand what does this mean, what do we in fact understand this approach. Basically, these regulations are subdivided into two categories. The first category is regulations which are mandatory, which are compulsory. And the second category is that there are regulations which are not mandatory, which are not compulsory to comply with. Now, if there is some regulation which is, and we will read these regulations, and I will differentiate that this regulation is mandatory, this regulation is not mandatory. So basically, if there is a regulation which is not mandatory to be complied with, the listed company has an option, has our discretion to act on that regulation or not to act on that regulation. And if the listed company opt for non-compliance of a regulation which is not mandatory, then that listed company has to explain that what is the impediment, what is the hurdle, what is the hindrance that the very company is unable to comply with our regulation, which is not mandatory. So this is comply or explain approach. Comply or compliance is meant for those regulations which are mandatory. Explanation is required for those regulations which are not mandatory. There you will simply render an explanation stating that these are the reasons which have made us redundant, or which has made us, or which has caused an impediment for the compliance of said regulation. So this is comply or explain approach. Let me invite questions before I will go for asking question. So first question, please.
Sir?
Yes, Ms. Hira.
Sir, I didn't understand one thing. If it's not even mandatory, so why is there even a need to tell, okay, why we're not doing this? Because it's completely up to the company, right? Whether they have to, whether they want to do it or not. They might have any reason, any personal reason, like a personal reason as in company wise, that they just choose not to do, not to comply on that. So why do they have to? And it might be a reason for that they do not want to disclose maybe. So why is it necessary to give an explanation for that?
Good question. Basically, as I said earlier, that there are two types of regulations given in corporate governance regulations. One type is mandatory. The second
Right,
type
right,
is not mandatory. So for
right.
only those regulations which are not mandatory, one can go for an explanation that, well, this is a regulation which is not mandatory. For example,
Mm,
there are certain mandatory disclosures that
right.
this is the board of directors of our company. One of the director has some interest in one of our subsidiary company. His one of
Mm,
his wife is in fact and has made an investment in one of our subsidiary company. So he has got some vested interest in one of our subsidiary company. Let's say this is the disclosure required by one of the regulation to be made to Securities and Exchange Commission of Pakistan, right?
right.
For this disclosure, you will have a mandatory regulation that if you will not disclose that one of the spouse of a director of a company has her vested interest in a subsidiary company of the company in which A is a director, then
Mm,
non-disclosure of this fact may entail penal consequences. There can be a fine,
right,
there can be an imprisonment against that director who did not make this disclosure.
right.
On the other hand, if there is a regulation which is not mandatory, non-disclosure of that regulation will not entail penal consequences. And
Gee.
resultantly, you will simply be rendering an explanation. I mean, here, even for a regulation which is not mandatory, SECP has not unleashed these listed companies. They have not given them unfettered powers that come what may, you are not required to disclose certain facts. They have said that if you opt for non-disclosure, you have to render an explanation. You have to give the explanation that what is the impediment for that disclosure. And maybe Securities and Exchange Commission will not, the registrar will not be satisfied with that explanation, and we will say that no,
Mm,
you cannot hide this information under the garb of
oh,
non-mandatory provision. You cannot escape the law under the umbrella of the provision which is not mandatory. Still, this can happen, right?
Okay, right. Say, okay, sir.
Got the point?
Yes, sir.
Brilliant.
Thank
So
you.
you're most welcome. Let's have another question. So please pose questions. Hira Nadeem Sahiba has asked a very good question. So please pose questions, enabling me to understand that you are on the same page. So I'm expecting another good question, please.
Excuse me, sir. Sir,
Ms.
what
Aisha
does it mean
Zafar,
by
please.
annexure appended to these regulations? I didn't get it.
You see, there are certain forms which are appended or enclosed or attached with the regulations. We call them annexures. And in fact, those are also considered the part of regulations. These are the forms which are, I mean, for example, there is there is a disclosure form. There is a form for making certain payments due by the company, and so on and so forth. So those forms are called annexures, which are appended or attached with the regulations.
Okay, sir.
You're welcome, Ms. Aisha Zafar. Next question, please. I'm waiting for the next question. You see, when I will start asking questions, there is an excuse that, you see, you people always give excuses that this was the impediment. And most of the time, the excuse is, I can't hear it, there was a reception issue, and so on. So please do not, this is mandatory to ask a question. This is not a non-mandatory regulation for this class. So do not take the benefit of, you see, impediment or an excuse, right? So,
Sir?
yes, yes, please. Yes. Yes, may I please have your question, please?
Sir, can you please explain the comply or explain approach again?
Okay, Ms. Benail Amer, I will. Let me take the attendance and then I will re-explain that. Mr. Abdul Rafi Sajid.
Present, sir.
Mr. Abdul Wahab. Mr. Abdullah Maqsood. Ms. Afsha. Mr. Ali Manan.
Present, sir.
Mr. Ali Raza. Ms. Aisha Zafar.
Present, sir.
Ms. Iman Mujahid.
Present, sir.
Mr. Umar Amjad.
Present, sir.
Mr. Haider Rafiq.
Present, sir.
Ms. Hira Nadeem.
Present, sir.
Mr. Kamran Shaukat.
Present, sir.
Ms. Minail Amir.
Present, sir.
Mr. Roshan Naeem.
Present.
Mr. Daniel Bashir.
Present, sir.
Mr. Fazal Aziz.
Present, sir.
Mr. Hamdan Khan.
Present, sir.
Mr. Raza Rahman.
Present, sir.
Mr. Fareed Ahmed.
Sir, present.
Mr. Saad Fawad.
Present, sir.
Mr. Shahjahan Gohar.
Present, sir.
Ms. Fatima Hassan.
Present, sir.
Ms. Tehreem Nadeem. Ms. Tahreem Nadeem. Mr. Taimur Idnan.
Present, sir.
Ms. Zarmeen Qureshi.
Present, sir.
Right. So let me recall the attendance for the last time. Ms. Tahreem Nadeem.
Sir, her Wi-Fi is very poor since yesterday. She was in the class and I think she even read it. Uska, I think Wi-Fi just went off right now.
Okay. Mr. Ali Raza. Ms. Afsha. Mr. Abdullah Maqsood. Mr. Abdul Wahab. Mr. Abdul Rafi.
Yes, sir.
Okay. All right. So here we go. Attendance is saved. And now let's move on. And we were discussing comply and explain approach. And Ms. Minail Amir has asked a very good question. So, and the good question was that please explain it again. Well, so listen it carefully before I will explain. Let me ask Ms. Iman Mujahid to read this once again for us, enabling us to assimilate this point. Yes, Ms. Iman Mujahid.
Comply or explain approach means discretion of a company with respect to non-mandatory provisions of these regulations, either to comply or provide appropriate explanation as to any impediment in its compliance in the compliance report along with the financial statements.
Okay. Now, Ms. Minail Amir, actually, the comply or explain approach, that is clause B of regulation 2, which define actually that what comply or explain approach is. In order to understand this concept, let's bear in mind that we have two types of regulations. One is mandatory. The second type is non-mandatory. For mandatory regulations, there is no excuse available to the listed companies. If they are not complying with those regulations which are mandatory, there are penal consequences. Penal means there is a penalty. Penal means that there can be a fine or there can be imprisonment awarded by the or in fact granted by either SECP if it is in case of a fine or penalty, or as per the standard scale, which are 3-level penalties: 1 level, level 2, and level 3 penalties, which are given in law. And as per those penalties, if the violation attracts the mischief of level 1, then of course level 1 penalty, level 2, and then level 3. These are the 3 standard scale level penalties available to the SECP. On the other hand, if the regulation is non-mandatory and a listed company has a genuine excuse that this is the reason that we are unable to comply with the regulation, which is non-mandatory, but this is our explanation that on account of this hurdle, we are unable to comply with this non-mandatory provision. Then this is the discretion of Securities and Exchange Commission of Pakistan to accept that reasoning. And if that reason is justified, then of course that concession can be given to the listed company. But if it is considered that the impediment, hurdle, hindrance mentioned by the listed company is illogical, is irrational, is not convincing, then of course that reason can be brushed aside and the listed company can be directed to comply with that. So this is actually comply or explain approach. Compliance for the mandatory provisions. Explanation option or discretion is simply meant for non-mandatory regulations. Ms. Benail, are you clear?
Yes, sir. Thank you.
You're most welcome. Okay, let's move on now. And now the next point is mandatory. That is the last definition given in sub-regulation 1 of regulation 2. Let me ask Mr. Temur Idnan to do this reading. Mr. Temur, mandatory, clause C.
Mandatory in relation to these regulations means such provisions that are constructed to be strictly complied with by the company, and non-compliance of such regulations leads to penal proceedings under Regulation 37.
Okay, you see, I have shared with you this content on Google Classroom. I did it day before yesterday, and I'm sure that now this is available with every student. These are the terminologies I have shared in previous lectures, and these terminologies are of key importance in order to understand Companies Act and these governance regulations. So do go through them, those terminologies, number one. And number two, these regulations, I have also provided a copy on our Google Classroom. So please make sure that before the class, you go through these regulations at least once. And if there is a difficult word, make sure that you have consulted the dictionary in order to pronounce that word correctly, or you have consulted the dictionary in order to understand the meaning of that word, because that will help you to enhance your legal vocabulary, and that will help you to develop better understanding. So the word read by Mr. Temur Idnan, that is construed. And earlier on, Ms. Tahreem has read for us the word that is repugnant. So I'm pretty sure that these are new words for you. So do acquire those words. Acquisition of language is an ongoing process. Though you are now in your final year of graduation, or you are at the verge of your completion or be graduated, but still, as I said, that acquisition of vocabulary is an ongoing process. So every day is a new day to learn new words. So construed, repugnant are the words used. Mr. Temur, please read this mandatory clause once again before I will explain it further. Mr. Temur Idnan.
Mandatory in relation to these regulations means such provisions that are construed to be strictly complied with by the company, and non-compliance of such regulations leads to penal proceedings under Regulation 37.
That's right. Now, Miss Iman Mujahid and Miss Benail Amir and Miss Hira, these actually, this clause has explained your questions to the optimum level. These, in fact, these are required, mandatory provisions are required to be complied with strictly, number one, and non-compliance will entail or will lead to penal proceedings. There can be penalties or imprisonment if these mandatory provisions are not complied with. Now, before I conclude this definitions chapter and resume our session in a while after a short break, because Zoom session may last another minute or two. So if there is any question, please. All right. So I have construed, I have understood that we have understood it well. So let's conclude our today's session, and we will resume next session in few minutes time.